Mr. Koshal, where is your adversary?
I do not know where it.
Dakun, item number 1.
My lord,
Maybe they'll be coming
They will be coming.
in a few minutes.
Achha.
My lord has other benches today.
From 12
At
12
12 by
noon.
2.
my lord, may I have your kind leave to mention one matter, my lord? The urgency is, my lord, the appeal is of 2017, my lord. Till
Second
date,
appeal.
my lord, yes, my second appeal, my lord. The injunction
It appearing
application.
in the list.
Yes, my lord, as item number 169, I'm praying for upgradation, my lord. As,
What is the urgency?
my lord, the injunction application is also pending. The respondents are trying to dispossess us, my lord.
The second appeal of
2017, my lord.
2017. This is 2026.
Yes, my lord.
9 years have passed by.
Yes, my lord.
If you have not been capable of moving the injunction application, then
My lord, many parties.
it can wait.
My lord, many parties have died in the meantime, my lord. Many substitution applications.
You can pray for substitution.
Yes, my lord. One substitution application is also.
Applications are there. Those will come up.
My lord, kindly, my lord.
No upgradation because this is not a regular bench.
My lord.
No upgradation.
Mention করো না, mention করবে? করো না।
My lord, may I be permitted to mention a matter, my lord? The matter has been fixed in item number 188 in the daily list, my lord. My lord, my client, my lord, is a very senior person, very old-aged person, my lord, is suffering from various physical ailments and difficulties, my lord. My lord, the respondent is a tenant over the property, and my client is a landlord, my lord. And he is living in a very posh property over the Kamak State, my lord.
Urgency.
My lord, ground of urgency is, my lord, since the last 30-40 years, he hasn't received a penny as rent, my lord. The opposite parties are just living in the property within the last 30-40 years, my lord.
Learned counsel, no upgradation.
My lord, my client is a very old-aged person, my lord. He's in a very dire situation, my lord.
No upgradation. Next. This being an irregular bench, not a regular bench, no upgradation. No.
I'm grateful.
My friend has come.
Yes, yes. Down. Item number 1.
Item number 1.
I'm for the response.
May it please your lordship.
Fact is that title suit 24 of 1997.
That is the earlier suit.
That one. Be kind enough to place the plaint
My lord, kindly.
and the judgment in respect of that one.
Sorry, what is the earlier
You are claiming no,
suit? What is the earlier suit? This is 5. 5 and 20.
the res judicata, section 11.
I said, assist your lordship. Trial by HON'BLE.
Why res judicata is being taken into consideration? So we have to go through the
Court himself has said.
title suit 27 of 24 of 1997. No, yes, 24 of 1997.
I can hand up.
No, it has been handed over, I think, on the earlier occasion.
ঠিক আছে। My place is one thing more.
এইটা নয় ওইটা দিন ওই যে এনভেলপটা দিন এখান থেকে যা বেরো
Before Mr. Ghoshal starts, my lord, I'm told that item number 2 and 3 will not be called on today.
it has been wrong. It has wrongly come in the cause list. It is for order. That is, hearing has completed. It is for orders.
Yes. So it will not be called on today.
It will be called on, but nothing will be effective. When the order is prepared, it will be passed. It will
No,
come
my
under
lord,
the heading. It will
I'm
come
not in
under-
High Court. If it is
It
not, my lord, called on, then kindly keep it on the next date, my lord, because I am not in High Court, my lord, I'm out of town.
Mr. Roy, it will come under the heading judgment or order.
Okay, today, my lord, kindly don't take any adverse step because, my lord, I am appearing and since I have.
Mr. Roy, it is wrongly appearing today. Somehow
Okay,
the court officer could not get it. It is wrongly
I'm
appearing.
grateful, my lord.
It will
I'm
appear
grateful.
under whenever it will appear under the heading
For
judgment or order.
Okay, I'm grateful, my lord.
My lord, I have done.
আমি আছি তো
Number আপনি আছেন?
No.
হয়ে গেছে।
Let me be clear. He could not understand on the earlier occasion. That's why he has placed in the cause list today. Whenever the order is prepared, it will appear under the heading judgment or order.
yes, my lord.
Because hearing is complete.
38.
He,
Yes, that was the impression, my lord, that the matter be placed under heading.
it is wrongly appearing today. Yes, Mr. Ghoshal.
নেম বি রেকর্ডেড মিলন স্বপন কুমার নন্দী NNN DI একটু কাইন্ডলি করে দেবেন
So on the last,
WF ফালান
Nandi,
ভুলে গেছি
Mr. Nandi, so on the next date, when the matter appears,
SWA
it will be rectified. It has been typed as Y.
Y and SWO A ho SWA 1 and I
It will be rectified on the next day.
And I am trying to assist your lordship in my humble way.
ওইগুলো দিন, এগুলো দিন, বাকিগুলো দিন, এই যে এইটা দিন। বোঝেন না কেন? বসুন 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 বসুন।
The 100 judge himself
Yes.
is saying,
24 of 97, yes.
my lord, so 24 is good for injunction.
Mm-hmm.
Kindly see, my lord, running page, it is 38 of this paper book.
38 of the paper book.
Hmm.
The paper book.
The order sheet.
এইদিকে খেয়াল রাখুন না, এইদিকে খেয়াল
It
রাখুন।
starts from 32.
32.
ব্যস্ত হও না।
Yes, the parties are Tarok
Very,
Da.
very, very important. Now, kindly see number the Tarok Das is the plaintiff, Mapi Das, Bulbul Das versus Ananda Mohan is the number 2 pro forma. My lord got it.
Tarok Das is the son of Shagor Das.
About that, those no controversies there.
No controversy.
Only thing is the whether adjudicator would be there because I am a pro forma.
In respect of Ananda Mohan,
Ananda Mohan.
son of late Hori Mohan.
Yes.
That is defendant number 2. In the
Pro forma defendant number 2.
pro forma defendant, yes, principal defendant is one sole principal defendant and the others are pro forma defendant, 2, 3, 4. Yes.
Now, kindly see.
What were the prayers?
Prayer kindly see. No, prayer kindly come straight to the prayer portion.
For a decree for permanent
Yes.
injunction.
Party restraining the defendant 1.
From making forcible possession of the suit property and from disturbing the peaceful possession of the plaintiff in the suit property. So,
And no allegation against me. No issue framed against me. No service upon me.
and now in the judgment,
Judgment was this court has held page
Mr.
38,
Goshan,
38,
page
38
38. Yes.
degree injunction against defendant 1. No injunction against me. No relief against me. Kindly see the relief granted. Injunction, the defendant 1 injuncted. Promoter.
So,
Page 40, I think, 11 portion.
So, according to you, order of injunction was sought against defendant number 1.
Degree was sought against defendant 1. And relief granted against number 1. I am nobody there. I only pro forma. Why pro forma? That has been also discussed.
Wherein?
The ground is that, well, I have given the page mark. I said, give my the page mark.
The paragraph number 12 of the plaint.
Yes.
That the plaintiffs requested the other owners, namely
Yes.
the pro forma defendant numbers
Yes,
2 to
35.
35, last line, to join in the suit as plaintiffs.
That indicates my ownership, co-ownership. no relief against me. And now kindly turn to the last page, the issue framed by the division bench, substantial question of law, whether it amounts to res judicata. Because no adjudication. Res judicata means a kind of prohibition against adjudication. No, I am not a party to the any really order of the court of no question of res judicata.
Where is the issue? Issue
Issue is only injunction, whether injunction should be granted against the proper.
according to the prayer portion.
Yes, that is all about this. Then the trial court decreed in my favor. Appeal court reversed it on the ground of res judicata only. Now kindly see what
That is the sole contention.
yes.
Hmm.
Now kindly see what is the
Yes, slowly.
While kindly see, come to page 7 of paper book.
Page 7.
Yes. Court himself is saying this, the appellate court.
Page 7 of the paper book.
Paper book, yes. Page 7 of the paper book.
Yes.
Decision with reasons.
Yes.
Just two small paragraphs. Kindly consider. The learned trial judge rightly observes that his appeal is the continuation of the suit and appeal is pending. Unless an adjudication is concluded, question of adjudication doesn't arise. Admittedly pending when the appeal was heard, the earlier suit was pending. No conclusion was there. The court himself is observing, and rightly so.
The appeal is. What are you doing here? What are you doing here?
The first two paragraphs are very
The appeal is pending. This appeal is pending refers to which appeal?
Another appeal between the co-sharers.
Bearing.
Four suits are there. 4 suits are there.
1 minute.
Out of the one in one suit, the appeal was pending. 2 suits appeal was pending. 17 title suit 17 is there. Another suit is there.
Title suit. The first one was title suit 24 of 1997.
Yes.
In respect of which no appeal was preferred by anybody.
No appeal was preferred.
Thereafter, title suit 8 of 2005.
Additional suit dismissed.
Dismissed. No appeal preferred.
No appeal preferred.
1 minute.
Now, kindly take trouble to see this one paragraph of this decision reasons. Appellate court himself saying appeal is pending, matter is pending, not concluded. No conclusion can be arrived therefrom. That is the language of this honorable judge.
Learned counsel, you are taking note of this one. Yes. Thereafter.
Next paragraph is important.
Thereafter, title suit 17 of 2009.
Yes. No conclusion can be arrived at therefrom.
In respect of which title appeal 205 of 2010,
yes.
which has been dismissed.
Yes.
And
my submission is that pending proceedings were there. No conclusion was there.
No, Mr. Ghoshal. So altogether there were 3 suits.
4 suits.
4, including this one. This one is arising out of title suit. This
2017.
20 of 2017, including this one, 4 suits. So overall 4 suits. Yes, we are concerned with
res
judicata, and we'll have to go through title suit 24 of 1997. That will bind or not.
Kindly excuse me to refer only few relevant portions. Kindly see the next paragraph of that the learned trial court rightly did not rely on. It's the finding of the appellate court which had decided against me on the ground of res judicata. Court himself is observing like this. Appeal is pending against it. That is the language of the honorable judge.
Hmm.
So if the
But,
constituted doesn't arise.
Mr. Hussain, just a few moments ago, you had stated that no appeal has been preferred against that partition suit, 8 of 2025.
Yes, that no appeal has been partition suit has been dismissed. There, I was not the petition plaintiff in the partition suit.
So can we consider the third paragraph of page 7, internal page 2? The learned trial court rightly did not rely on the judgment and decree of title suit 8 of 2005. Since appeal is pending against it,
No appeal is pending. At that point, there was an appeal, but that was not concluded at that point of time when this matter was heard. When this matter was heard, what my lord is hearing now, when this matter was heard, then that appeal was not pending. No appeal was pending against Section 8. That is why the honorable appellate court has discarded that thing. Because no appeal was pending regarding 8 at that point of time. We are concerned with whether at the relevant point of time another proceeding was pending. Answer is no. Someone kindly take trouble.
so this one is not the correct view of the trial court, that appeal is pending.
Trial court has knowledge of the title suit or the appeal, but has not taken cognizance legally of that thing and has discarded it. They are cannot res judicata unless there is a conclusive adjudication.
Yeah, that is obvious.
Pilot kindly pilot take trouble to the last page of the paper book. What formulation was there? Page 35, 135. Last page. Kindly see the point says whether the kindly see there is no evidence of service of someone upon my client performer or dependent on HON'BLE.
You are referring to the substantial questions of law.
Yes. Kindly see first question is whether there is service upon me. Answer is no. No evidence on the judgment.
As
Next
regards to
one,
first one, yes. Second one,
Next point is very important. You apply the res judicata apply on the ground the appellate was the made party in the earlier proceeding as pro forma dependent. Whether it is applicable to pro forma dependent. Second point.
Mr. Ghoshal, in respect of the first substantial question of law, it was not
No service.
at all served.
No service. No written statement. No issue frame. No adjudication.
No.
And relief is also only against one.
Whether written statement has been filed or not, that is latter problem.
Secondary thing. A fact is that there is no service, no appearance, no issue.
Yes.
And in relief also only on injunction only against one defendant one.
That is appearing in the
no order against me. So that is our first point. The second point, whether it is applicable to pro forma defendant. In fact, there is no such thing as pro forma in the civil procedure code. We use it as for the sake of form. And admittedly, our client, Anando was the co-owner or owner of the property in question. That is the evidence from the record itself. So, no grievance against me. She wanted to make me a party. I refused. That's why she made me pro forma defendant. That's what my friend has read out. Page 5.
No,
this yeah. Okay. Anand was approached by the plaintiff of the suit to join hands. He refused. That's why he was made pro forma. Therefore, my client has no insight adverse to that of the plaintiff or is plaintiff of that suit. And to cut short the matter, if my lord I seek indulgence, if my lord permits me, I shall just give the I once I gave it. If relevant pages only. My lord will can see it from whatever the question my lord arises, my lord will get it from there. I shall tell it after I conclude my submission. So that is the first point, no service.
Yes.
Then pro forma has no role really, not a single allegation against me in the plaint. Page 32.
Yes.
32.
Page 35 and 36.
Page 35, paragraph 12.
Last paragraph.
And prayer is at page next page 36. Only against one, defendant one,
Yes, yes.
yesterday given a one. These are true to my knowledge. Then the verification says these paragraphs are true to your knowledge.
Yes.
Now the further clarification is available at page 38. The order are passed upon it. Very clear order.
Yes.
ঠিক আছে
So that is all. The next question is the next point of substantial question is last question is
Whether the principle of res judicata.
whether the question of res judicata can be point is formulated. The clause number 3.
That
Whether
has been answered. That has been answered.
and the
Made,
third point
made,
is
only, made only pro forma respondent. No relief sought against the said respondent, and not served.
yes. Next is whether the principle of res judicata can be extended to a party against whom no relief is claimed. That is the third point.
Third substance.
That is not the. And without disturbing your lordship, I may again repeat the one word. At page 7 of the running page, 7 of the paper book, the decision of the reasons first two paragraphs are very important for us.
The learned
These
trial
pending
judge.
proceedings were there. This is court's own finding in the decision with the reasons.
But you have stated that no appeal was pending at that relevant point of time.
That is the fact.
That is fact.
Thank you. There's no other thing is coming. Now the another thing I'll ask for me about this page 99 deed. Paperwork page 99. Deed of 1939 of my predecessor. Fulvashi and Jogoma. This deed of 1939, not challenged, not set aside by any court of law. Rather, it is relied upon by both the parties in this out of these 4 proceedings. That is exhibit number A in one case, exhibit number 11 in one case. They relied upon this as exhibit, their exhibit, admitting my ownership.
You, Srimati,
Apart from series of statements, quite obviously, that my client is the son of the one of the heirs. This deed is unchallenged,
Hmm.
and that's the source of title of the party, and that is relied upon by both the parties in their respective suits. In one suit, in page 57, can you see page 57? Page 57, latter portion, exhibit 1,
57.
latter portion, exhibit 1.
Exhibit. Yes, last, let us now examine the documents
Yes.
regarding exhibit number 1.
39 document.
Hmm.
Another exhibit.
This deed.
This deed, yes,
in
this
page
deed,
99.
this deed, 13, date is 39. And another exhibit number is exhibit A at page 49. Filed by other side in their suit. ঠিক আছে বুড়ো আছে পায়ে প্রবলেম আছে মার্চ মাস জানুয়ারি মাসে 80 বছর হবে
What is the number?
Yes.
My lord got it.
Hmm.
So that document is not even the fact that has not been challenged till date.
Hmm.
That is reigning the field.
Hmm.
That is relied upon by both the parties, admitting the ownership of the party.
The deed of 1939.
So there is it is anybody aggrieved if any. They could have challenged it before any court of law to set aside the document. Nothing has been done. Other relied upon as an exhibit. So they cannot go beyond that. And the question is that if I have a better title, I am entitled to the degree. If I have a better title, sir, my lord, we have relied upon a judgment of Justice R. Bhattacharya. Year 1975, Calcutta page 200. There, the suit was for a revision of a premises tenant. The plaintiff failed to prove the relationship of landlord and tenant. Still, degree was granted under Order 7, Rule 7, because of the fact that the plaintiff has a better title. Plaintiff proved the better title. Here, I have proved the better title than the other side. Other side is a stranger to the family. And my lord, kindly, before I conclude, my lord, kindly excuse my indulgence. To take note of certain pages only. If my lord so considers, my lord can take assistance from those relevant pages. Page 32 to 41. Paper book. Paper book.
You have initially you have relied upon page 35, 36, 57 and 7.
Kindly excuse me.
No, now page 30.
Kindly, again, I'm giving the final list. Page 32 to 41.
32 to 41, yes.
Page then amongst these pages, particularly paragraph point of page number 7 and 8. 24.
32 to 41 is
Total page. Out of that, 7, 8, and 24 are the important.
paragraphs.
Page 7 and 8.
Acha, you are referring to the internal pages.
Yes, internal page. Running page. Then 42 to 47. And exhibit A, my lord would find in page 49. And lastly, two pages are there, 55 to 57. My ownership has been proved beyond doubt. I am the owner. And so I have transferred it as upon my ownership. because in view of the deed of 1939, relied upon by both parties, my title is very much admitted. I have a better title than the defendant herein.
Yes.
Therefore, my lord, some confusions are there. Probably, with all respect, I am submitting with the mind on judge in the appellate court. Probably, my lord, his attention was not drawn to all those things because the record shows otherwise. Record itself is very clear. That's why, my lord, I am kindly excuse my impertinence.
No.
I am insisting so much on the relevant pages because those very pages will be self-explanatory. It will go to show my ownership on the one side and the status of the other side in the other side. Everything is very much clear. So there is no scope of disturbing my judgment in the trial court. Trial court rightly had decreed the suit because my ownership is proved. I am realizing rent. He says he is not in possession. He has inherited. He is the heir of such and such, but he is not inherited. If I am the heir, I will inherit. Inheritance is automatic by operation of law. Inheritance is automatic by operation of law. If you admit me to be my predecessor to be the owner, if you admit me to be her son, then my inheritance automatically comes in. It automatically comes in, and then I become the owner of the property. And in the municipal record, my name is there. I am paying taxes. Possession doesn't mean always physical possession. There is a provision of constructive possession. Possession of the tenant is a possession of the landlord. This is called constructive possession. In partition suit, there may co-sharers may reside in different places. Possession of one co-sharer who is looking after the ancestral property, his possession is the possession of the other co-sharers, unless there is a case of complete ouster, which is a very rare case. No such case is there. So my ownership is undisputed. My status is undisputed, and admittedly, as per the judgment of the appellate judge, the other proceedings were pending. No complete adjudication was there. So no question of res judicata. Res judicata is kind of prohibition against subsequent suit. Yes, that's one. But these pages are very
পায়ে ব্যথা তো হবেই, খাওয়ালে না সিনে কেমন পাওয়ার পর পায়ে ব্যথা হবে না? Not for court. No treat for us.
Old man is too old.
So what?
It's too much for me for this at this old age to get.
Who is older?
Needless by myself. I have enrollment of 1970. 56 years running. He's my young brother.
Neither 50 years celebration has been made.
It is for the stalwarts, not for ordinary lawyers like us.
No, my lord, here is question is, my lord, we have argued that matter. Now you know, probably
Mr.
has, my lord.
Mr. Ghoshal has said in page number 7 of the paper book. Page number 7 of the paper book. Third paragraph. The learned trial court rightly did not rely on the
Cannot find it, madam.
third paragraph, page number 7 of the paper
7?
book. Third paragraph.
Oh,
The learned trial.
second paragraph. What paragraph nahi? The learned trial judge did not rely on the judgment and decree of such and such.
No, whether all the words written there are correct or not.
The learned trial right cannot be in view of the appellate's court order. It cannot be.
According to Mr. Ghoshal, at that relevant point of time, no appeal was pending. It has been mentioned that the learned trial court rightly did not rely on the judgment and decree of title suit
Since
8
his
of 2005.
appeal is
Since
pending
appeal,
against it.
Since appeal is
However, as
pending
counter
against
claim
it.
was dismissed without going into the merits of the case. On that date, it was may be pending. Appeal may be pending.
No, according to Mr. Ghoshal, no appeal was
Wrong recording.
No appeal was pending. Is it so?
Out of 4 suits, two appeals were pending in 2 other suits.
No,
Maybe. About this, no appeal was there. But
we are concerned with
allied matters. If the appeal
we are concerned with title suit herein. We are concerned with title suit 8 of 2005. Whether appeal was pending in respect of title suit 8 of 2009.
At least there is nothing on we have found in the record. But there are appeals were pending in respect of 2 other allied matters. Those are allied matters of the same party, same holding. That my lord,
My submission would be this: my lord, square, you have to inquire and my lord, appraise my lord. My submission before my lord is very short. These document deeds which are relied, not relied, interpretation, not interpretation is totally irrelevant if my lord is with the point is with me that the matter is res judicata. Your title has the decision is res judicata.
According to Mr. Ghoshal, 1 minute. This appellant herein was pro forma defendant.
But there can be pro forma defendant. In civil procedure court, there is no pro forma defendant.
He has stated also same thing. There cannot be any
Defendant. He was defendant.
And in that title suit, relief of injunction was sought in respect of the sole defendant, that is defendant number 1.
Maybe.
But
But incidentally it is decided then. If it is incidentally decided, may not be claim has been paid. By reaching at the conclusion of the prayer made in the plaint, if something else is decided, that is also res judicata. The Supreme Court says so.
Here nothing has been about my client. Sorry.
Mr. Ghoshal, you will get
No, Mara did not be worried.
No,
I can handle.
No, Mr. Ghoshal, you will get time to give the reply.
I will not make my submission. Can you take my written submission? Our written submission confined only res judicata. If the res judicata fails, then this question may crop up which has not been decided. Can it come to paragraph 5? We have categorically taken, my lord, the Justice Partha Chatterjee's order, categorically read here from the copy of the plaint.
I don't think this is of Justice Partha Chatterjee.
No. I know that. I know that. The landed additional 11 additional Justice Alipur, while dealing with the appeal, rightly held. What is the held? From the copy of the plaint of title suit number such and such, it is evident that the defendant number 1, 2, 3 claimed title through Sagar Das. The court was held that the plaintiff Tarok such and such 3 claimed as co-owner of the suit property, having inherited the same from Meghnad. And on perusal of the evidence on record as well as on the absence of any challenge, there was no reason to reject the prayer of the plaintiff. Thus, the decision on the question of possession is res judicata on the question of title to the extent that adjudication title was essential to the judgment of title suit number 24 of 97. It is incidentally decided. While deciding the title, my lord, incidentally court may decide on the possession also. This lower appellate court, my lord, had categorically held on the giving emphasis on the point of res judicata.
Yes.
Then, my lord, kindly proceed. Paragraph 6. In this regard, the learned 11th additional district at Alipur would further like to add that according to explanation Roman 411 of the court, the denial of title of the present defendants respondent in the suit property might and ought to have been made a ground of defense by Ananda Mohan in the former suit. I was clear to my lord. Explanation through Roman 4. It is ought to have been taken. If it is not taken, barred. Being title number 24 before the learned judge, second court, and as such, it shall be deemed to have been a matter directly and substantially in issue in that suit, and that question cannot be reopened at this stage. The appellants once decided as having title in the suit property cannot be held to be the trespasser therein. Thus, the observation of the learned trial judge in this regard are reversed and set aside. But we have thoroughly checked up. My learned assisting me has thoroughly checked up and culled out the portion which suggests res judicata. If the res judicata is held, then other question need not be gone into. Can we now come to paragraph 7? Though after a clear finding of res judicata on the question of title of the parties in the suit property, no trial can be conducted to reopen the issue title, And the purpose of determining whether Jogmaya died unmarried is nothing but an attempt to re-ascertain title. Therefore, the admission of the death certificate of Jogmaya as additional evidence at the appellate stage is not only meaningless but also prohibited by law. Moreover, it does not appear from the lower court record that the appellants ever attempted to call for the municipal records to prove that Jogmaya died unmarried during the course of their evidence. The said document was obtained in the year 2005, that is long after the institution of the suit. Yet the appellant did not take any steps to produce a duplicate copy of the Jogmaya's death certificate. It is also not their plea that they were unaware of the fact of Jogmaya's death as an unmarried person. Thus, the requirement of the due diligence is not satisfied. As such, evidence could have been produced at the time of reading their evidence. Accordingly, the application of 47 were also negative. So, 2 points here considered. And on that point, we have relied on 2 Supreme Court judgments, that is paragraph 8, my lord will find that also we have handed over to my lord. If these 2 points is my lord is with me, which the lower appellate court has giving reason altered of the trial court, and come to an independent finding. 2 things. Yes, lower appellate court, if it is altering, 2 things required to be done. One is he has to say why the trial court was wrong, and he has to come to your own independent finding. These are both, my lord, apparent according to my humble submission on the records of this case. So that's why, my lord, this court in the second appeal need not go to the appreciation of evidence or other things.
And so according to you, incidentally, in title suit 24 of 1997, it has been decided, so it cannot be.
You cannot, under Roman 4 of 11, section 11, you cannot reagitate this. It could have been said there. And that's the specific finding of the lower appellate court.
Their contention is that summons were not served.
Can it be now agitated in a second appeal before my lord? I'm asking the question to myself.
Question formulated here.
Maybe.
Second substantial question of this.
Maybe. Whether your lordship goes, at the time of admission, my lord, several questions are found. If my lord thinks no, whether in that suit someone was served or not is a relevant question, then there is no other alternative but to remit. But this point has been agitated and decided. And I repeat, my lord, lower appellate court has come to an independent finding also.
First appellate court.
First appellate court. So long, this practice of so long, my lord, it will take time. The first appellate court, my lord, not only discard the finding of the honorable trial judge, but also give his independent finding why it is barred. And if it is barred, then other question need not be agitated at all. That is all, my lord. I will not make any other submission.
I should not repeat.
Yes,
Only
I don't think any reply to is required.
The only thing is that question is that the fact remains that in the second suit, after the suit number 24, the partisan suit was filed against me. The moment this partisan suit is filed against me, I am treated as the co-sharer or co-owner of the property. Your ownership is admitted. And thirdly, there is no cogent reply to the admitted document of the 39 regarding my ownership. If I have a better title, admittedly the defendant is a stranger to the property.
This question cannot be agitated even because of the res judicata. If res judicata is not there, these are the valid question to be decided.
The res judicata doesn't apply because no identical issue is adjudicated.
This point can be urged.
No identical issue is adjudicated, which is now being adjudicated. That was not the issue in earlier suits. There is a creation of these suits appeal. Before that, in so many suits, in the other four suits, the question of res judicata is not the issue in any of the suits. Quite obviously. And the plaintiff of the suit, my friend's client, has admitted that my client was approached to be a plaintiff, being a co-sharer, but he refused. That's why he was made pro forma defendant.
There is nothing pro forma. He was defendant, contested the suit.
Pro forma is whatever may be the legal position, I am referring to the judgment in question. That means no relief. Pro forma means no relief is claimed
No,
against
that
him.
is, I repeat, Mr. Ghoshal, don't say anything which is not fine press in the civil procedure code. There is no pro forma
No,
defendant.
you also know it. It is not these judgments. We have not written the judgments. My lords have written the judgments. The question is the language is very much there. Pro forma is in the note. That means we mean it in this way. No relief is claimed for against him. Pro forma is for the sake of form. He is a proper party, not a necessary party. That is other thing. But that does not affect the merit of the suit. There is joint issue. For that technical point, the merit of the issue cannot be disturbed because I have admittedly a better title.
উঠুন ডিকটেশন নিন সেখানে আপনি জাজমেন্ট দেবে moreover what
নিন।
So I get extra impetus when my friend is on the other side.
No, he gives impetus to everybody.
I get special.
But I told Justice Sanjeev Banerjee that why you waste your health? Neither your matter, not my matter. We are brought by paying our fees and we are getting your salary. So why we should create such an atmosphere in court that we are enemies?
We are concerned within the purview of the facts which are being placed and the law
I
point.
say there is no enemy with Mr. Ghoshal with me.
That's why
Clients may be enemy.
the word submission.
No, submission sometimes is
Best.
my lord is afraid, and that's why I close it. Can you recall one? Just a second. Justice Siddhartha Rai Chaudhary.
Hmm.
If I enter into courtroom,
Hmm.
my matter is not there. Another matter is going on. Live streaming is going on. He immediately say, "Stop the live streaming." Hello, why, my lord? I am not in this matter. No, you can't be believed. Whatever you will say, it will be viral then.
Heard the learned senior counsels. Heard the learned senior counsels representing the appellant and the appellant. Appellant and the respondents. ঠিক আছে? Full stop. At length. Hearing is complete. Full stop. Reserved for judgment.
না
Yes.
এটা হতো না my lord শরীরটা খারাপ হয়ে গেল মাঝখানে
There has been a
that's why
gap because of illness.
not health.
It will so happen, and especially it may happen in my case. I'm steadily heading towards a catastrophe.
চলো আস্তে আস্তে চলো Get food.
Thanks to both of the learned senior counsels for their cooperation.
In all matters.
I'm a very junior to Mr. Bobas.
চলো চলো
Chalo.
এটা কিন্তু কমপ্লিট হলো বুঝেছেন এটা পুরোটা পাঠিয়ে দেবেন হলো? কিছু কিছু হারাবেন না সব পাঠিয়ে দেবেন কিন্তু নেক্সট আপনি
Mr. Anirban Mitra is appearing on behalf of the CBI, my lord.
কোথায় appellant who is for the appellant
My lord, learned senior advocate Mr. Shondipon
You are representing the appellant
No,
or
my
the
lord, I am
you're-
Mr. Honorable Mitri is appearing on behalf of the CBI. my lord.
CBI? You are representing the CBI. নিন আচ্ছা পাস ওভার था
My lord, kindly take it out at 2 p.m. my lord.
next the 2 p.m. this bench won't be available. নিন আচ্ছা নিন নিন দাঁড়ান অর্ডারটা নিয়ে নিন none is representing record ফাইলটা দিন ওটা আগেরটার ফাইলটা দিন none is representing the appellant while the respondent CBI is being represented. Full stop. As the appellant is not being represented, the matter cannot be proceeded today. Full stop. Paragraph. Let the matter appear on the next day when this bench is available. Provide your name.
Okay.
You may not be in the panel, but
Okay,
you have
my lord.
mentioned it.
I understand.
Even next ডাকুন আপলোড করলো কি করে কে করেছে এটা পাঠিয়ে দেবেন আজকে ফাইলটা পাঠাবেন আর ওনাকে পাঠিয়ে দেবেন 4:30 ঠিক আছে নিন প্রথমে লিখুন আইটেম নাম্বার এটা 5 প্রথমে লিখুন in the order dated 24/7/2026 it has been wrongly mentioned as WPA 3112 of 2014. Instead, wrongly কি বলেছি ঠিক আছে এটা সিঙ্গল ইনভার্টেড কমার ভেতর দেবেন WPA 3112 of 2014 in single inverted comma close. Instead, it ought to be CO 3112 of 2014. এইটা ডাবল ইনভার্টেড কমার ভেতর আর বোল্ড করে দেবেন আর আগেরটাকে বোল্ড করতে হবে না এই সিঙ্গল ইনভার্টেড কমা এইটাকে ডাবল ইনভার্টেড কমা এবং বোল্ড the said order therefore mentioned order be modified to such extent. দুটো লিখতে হবে যে কোনো একটা aforesaid বা aforementioned order be modified to such extent only. Full stop. Paragraph. Neither the petitioner nor the respondents are being represented. As such, the matter cannot be taken up for hearing. Order is modified to such extent only. Next,
in this matter, my lord, I am for the respondent. Upon notice, my lord, in fact, the matter has been mentioned before your lordship and accordingly appeared. In the instant matter, paper book, requisite number of paper book has been filed.
1 minute. You are for the appellants? No. The appellants are not being represented today.
No,
You are for the
respondents, and I have prepared paper book out of court, and the requisite numbers of paper book were filed
with the department.
with the department as well as with the learned advocate for the appellant.
A copy has been
Yes,
provided to them.
and in the meantime, appellant number 11 expired, for which a substitution application has been prepared and that is pending. If your lordship's pleasure is to take up the substitution application,
That is Can 2 of 2025.
yes. And if that application,
Nobody is representing the appellants today.
yes, upon notice, in fact, I mentioned the matter, my lord. My lord, twice I
You
gave
had
the-
mentioned.
Yes. At my instance, the matter appeared. Therefore, I am praying before your lordship, if the substitution application is allowed, I have no objection.
In the absence of the
My
other side.
My
It would be better you serve the notice that the matter will be taken up
On the next
on
occasion,
the next occasion.
when your lordship will be pleased to sit on, please to take up the matter.
That is, whenever the bench is available.
Yes.
Kindly give a notice
Yes,
to that
yes.
effect.
In course of today, if not possible, in course of next week, I shall give. In course of Monday. In course of Monday, if not possible to serve notice on today, then in course of Monday, I shall
Should be
serve.
served within Monday,
Yes.
as early as
Yes.
possible.
Yes, ma'am.
Nin. Item number 6. Essay হচ্ছে 16 of 2020. The appellants are not being represented while the respondents are being represented. Full stop. An application seeking substitution of the
Appellant number 11.
appellant number 11 being Can 2 of 2025 is pending. The said is pending, full stop. The said application cannot be taken up because of the absence of the learned counsel representing the appellants.
Yes, I am for the respondent. Yes.
On the earlier occasion, the appellants were being represented.
Yes, on that day, I mentioned the matter before your lordship. At the first.
On 24/7, the appellants were being represented.
Yes,
But today, respondents are being represented while the appellants.
No,
are
my lord, may I humbly submit before your lordship. On that day, on 24th, I, upon notice, moved the matter, mentioned the matter before your lordship to appear as marked to be mentioned, stating the fact. And your lordship's pleasure was to give a direction to appear as marked to be mentioned.
Okay.
And when the matter subsequently called on, I was not there.
In last sentence,
Cannot be taken up because of the absence of the council representing the
appellants, paragraph. In such circumstance, the learned counsel representing the respondents is requested to serve a notice intimating the learned counsel representing the appellants, mentioning that on the next date,
Right.
when this bench is available, the matter will be
Right.
taken up. Let the matter appear on the next day.
My lord, only the can number 2 be taken up, madam.
Yes.
is requested to serve a notice representing that on the next day, when the bench is at
একটু দেখে শুনে টাইপ করবেন, বুঝলেন তো? একটু গন্ডগোল লাগছে, ঠিক আছে? Yes, next.
Item number 7.
Yes.
Your Lordship, this matter was heard for some time, long back. Then your Lordship passed directions for affidavits. After that, it has come.
My lord will kindly see the last order of
30th January.
30th of January 2026. In course of hearing, it was
Some submission being made, council representing the petitioner. It transpires that in this list, amended plaint has been filed prior to passing of the impugned order. Prior to passing of the impugned order, that is the order dated 14/11/2024, passed in the miscellaneous appeal. As such, Miscellaneous appeal under miscellaneous appeal under order.
uh, uh, under order 41 rule, your lordship, against the injunction order granted by the trial court.
Acha, acha. Miscellaneous appeal against the order of injunction.
Injunction.
As such, the amended plaint is required to be produced. As such, the amended plaint is required to be produced, and written objection against the injunction application
Yes.
filed by the petitioner before the trial court has also not been furnished. That is also required to be taken into consideration. The petitioner seeks fortnight to provide the same. The petitioner. Yes. So, the injunction application and the objection.
Well, this is my affidavit in opposition on behalf of the opposite party numbers 1 to 4.
1 minute. The injunction application is in page 8. Oh no, this is a written objection. Where is the injunction application? Injunction. Mr. Srivastava, which page contains the application? তখন চাইবো ঠিক দেবেন। You have provided the written objection.
Because your lordship, I did not have a copy of the amended plaint, but he has annexed it.
No, my lord is asking
No,
about the
injunction application.
injunction application.
That is in the original matter. Because
If my lord takes my opposition, I have annexed those documents to my opposition.
Both the application, objections.
Objection as well as the amended plaint. Kindly takes it up once, my lord. My lord will see that.
First, the amended plaint, that is page.
Yes, my lord will find the amended plaint at page number 13 of my
13.
opposition. Thereafter, my lord, the written statements I have annexed, they begin from page number 23.
Written statements, we have dependents number 1 and 2.
Yes, my lord.
23, 2.
23, my lord.
I'm defendant number 3.
Defendant number 3.
Yes.
You have also
Yes,
given the written statement.
We are contesting.
My lord will then see the injunction application at page.
No. Thereafter, written statement on behalf of defendant number 3.
Yes, my lord.
29 to
29 to 37.
37.
That is the written statement number 3.
Thereafter, the injunction application.
Thereafter, the injunction application from page number 38.
38 till. What is page number 50?
50.
50.
My lord, I'll just check. My lord, page number 50, my lord.
Deed or agreement, this.
Yes, it is an annexure to the injunction application.
Annexure A.
Yes, my lord. It's a copy of the tenancy agreement, annexure A. We'll try to come up with a better typed copy,
Yes,
my lord.
page 50 is
And
not
your
at all
lordship will kindly see
legible.
page 50 is
Yes,
black.
we'll have to provide a. I'll provide a typed copy.
Yes.
I'll provide a
We
typed
kindly have
copy,
to
my lord.
provide a typed copy. Thereafter.
57 also.
57 also. Rent receipt, I think.
Yes, 57, 50. We'll provide typed copies of.
Rent receipt.
Yes, my lord.
57, 58, 59. And
all these papers, my lord, I'll provide typed copy.
60. Yes, I think typed copy is
That would be better. Till page 60, my lord.
Till page 60, yes. So anything more required?
I don't
No,
require.
written objection also I have annexed, my lord, at page 69. If my lord kindly
Yes,
sees
yes. Written
against
objection,
order
yes.
39, rule 1 and 2. Filed before the trial court.
All the trial court papers are there.
Yes,
Yes,
my lord.
written objection from page 69 to
72. Yes, my lord.
and from 73 onwards, that is the written objection on behalf of the defendant number 3.
Yes, my lord.
So nothing more is required.
All documents are here. I'll provide
Only
type.
those documents which are
Nil.
dark, that is.
Nil.
Your lordship will kindly fix a specific date. January it was heard. We are here, it was
Whenever it is convenient to my
Specific.
lord.
no, little bit higher in the list. That will do. Whenever your lordship says. No, let there be no date, but higher in the list.
It is appearing as item number 7.
7, that is.
To be mentioned, let it be in the first group for hearing.
One has been completed. Second is also
2, 3 is or for CAB.
1, 2, 3.
Yes.
But this is not appearing for hearing, but as to be mentioned. Let it appear for hearing.
Yes, that is true, my lord.
So let it be in the first hearing group.
Line upwards. It will be as item number 2 after the criminal appeal.
Yes, but for hearing, in the heading, under the heading hearing.
Next Friday.
Next
Friday.
Any day.
So you have filed today supplementary affidavit and affidavit in reply.
Yes.
Supplementary affidavit has been filed on behalf of the petitioner. Full stop, paragraph. Affidavit in opposition has also been filed
My lord, by opposite party numbers 1 to 4.
on behalf of the opposite parties number 1 to 4. Full stop. At this stage, the learned counsel representing the petitioner also files the affidavit in reply. Full stop. Let the affidavits be kept with the record. Full stop. On perusal of the affidavit in opposition, it transpires that the annexures to the injunction application are somewhat illegible. Let a typed copy be provided on the next date. Full stop. As the matter is ready for hearing, otherwise, let the matter appear under the heading hearing. On the next day, when this bench is available.
Any date your lordship
Can't
will
we
say?
can't we take up today? Can't we take up today?
Because the documents are still illegible, that
Okay.
might create a difficulty.
When this bench is available. On the next date.
First group, first hearing back.
No, second.
Second.
Criminal.
Item number second,
Huh.
2, but in the group hearing group under hearing.
Under the hearing, it will be second.
Yeah.
Criminal appeal, they are after this one.
I'm grateful to my lord.
Hold. Next.
Item 4, item 4, I apologize. I was 237 while coming, it got called. It's like coming from Jalpaiguri to I was in 237.
Can you bring the learned counsel representing the CBI?
I'll have to call him. He's also left.
I don't think the matter
Till
can be taken up
12.
today
Till
because till 12.
Very well, Your Lordship has fixed it on the next return.
Yes.
I will do it, We are ready, We are ready.
Come ready on the next date positively because that will be under the heading hearing as item number 1.
Friday, this next Friday.
When this bench is available.
Very.
Next.
Item number 8.
Yes, I am for the respondent, Milord.
Item number 8, my lord, Mr. Partho Protim Roy is appearing, my lord, but he is engaged in court number 7, my lord, praying for Passover, my lord. He is on.
Milord, can it be fixed at 12?
No, this bench is available till 11:55 because there's another bench at
So,
12 noon.
then the matter correct is at 11:50. By this time, I will be also reaching in the court, and they will come so that in presence of both parties, the matter can be decided. I am praying for vacating of the stay. Vacating of the stay.
Yes, you are representing the respondents.
Yes, yes.
Let it be passed over.
All right, I am coming by 10 minutes.
But I cannot assure whether the matter can be taken up or not. If any other matter is taken up, it will continue. It is being passed over.
All right.
Next.
Item number 9. May it please your lordship, I am on behalf of the petitioner in this petition.
ডিসপ্লে হচ্ছে বোর্ডে You are representing the Union of India? Oh, no.
I mean, next item.
Where is the Union of India? Mrs. Chandri Alam. Nin.
They appeared on the last occasion, lordship. On last several
Nin,
occasions.
the petitioner is being represented. The petitioner is being represented, but the respondent Union of India is not being represented. Full stop. In such circumstance, the matter cannot be taken up for hearing. Let the matter appear on the next date when this bench is available.
Shall I serve intimation to the other side?
It will be better. It will be better for you only.
They will be available. Great. Item number 10.
For the appellate, my lord, there is a substitution application which has not appeared, and in the file, my lord.
Can 13 of 26?
Yes, 13, my lord.
Kenta. Down. No, এখানে নেই, দেখুন ওখানে কোথাও আছে কিনা, ওখানে থাকা উচিত। এটা তো অর্ডার। Yes, can 13 of 26.
Can কটা আছে?
I appear in the respond number 1. Very old matter, my lord.
Lordship, allow the substitution application.
I have no objection.
Fix the date, my lord.
Fix the date for hearing. Otherwise, matter cannot be.
He is not opposing.
Which paragraph, Ms. Chakraborty? Who has expired?
Lordship, 2 person, lordship.
2.
2 persons.
2
Respondent 2 go. That is lordship for substitution after setting aside abatement on condonation of delay. And lordship respondent number
after how many days? Beyond 150?
Yes.
And 4.
Originally 2 or 3 say a respondent. Now it is a perhaps.
Partition suit?
Yes, my lord.
Then it is the
249 days delay, lordship. Though it's a partition suit, it does not have it.
in paragraph.
Challenging the preliminary decree, there is a partition.
Paragraph
Let us proceed step by step. In paragraph number.
Paragraph, lordship.
2.
Page 31.
Page 30. Page 31. Nin.
That during pendency of this appeal, defendant respondent number
Shobharani Koyal.
Yes, died in the year 2025, leaving behind
her legal heirs are 4 sons and 3 daughters.
Yes.
7 altogether.
Yes.
1, 2, 3, 4, 5, 6, 7. Yes. Nin.
And the defendant respondent number 4, Ajit Mondol, he died on 30th of December 2025, leaving behind 3 sons, 4 daughters. Again 7.
3 sons, 4 daughters. Nil. No objection?
Lordship, Shobharani died on 11th May 2025, the last line of page 32.
My submission, my lord, the matter, my lord,
Fixed
time
for-
my lord fixed for hearing, my lord, all the records, my lord,
Mm, mm.
substitution come in the picture.
Otherwise, it is ready for hearing.
Yes, others.
Otherwise, ready
Be,
for
be kind enough to be present. The matter will appear as item number 3.
My lord, lordships kindly fix any date because Mr. Ashish Bakshi will appear as a senior, my senior, my lord. So, 14th,
can I-
14th August,
I'm-
Lord, the,
14th.
he is the
I am,
person.
yes, I know very well, but I am unable to fix any date
My lord,
at this present moment.
my lord.
Oral
It will remain in Friday, my lord. My lord.
Oral lords is in place of item number 3. It would be, my lord, the item number 1, so that, my lord,
No, no,
Cannot
1,
be.
2 ধরে গেলে 3 ধরবে না।
Cannot be.
no. শোনো আশিস বাগচি আসবে অত দূর থেকে একটু চিন্তা করো
কি হলো? Nil, nil. The learned counsel representing the appellant. Mr. Bakchi will be representing the assisting,
appellant.
He's leading.
leading that.
Appellant.
No. The learned counsel representing the appellants. Appellant or appellants?
Only one appellant. All respondents. Appellant only one.
Oh,
কত দল?
now not only, yes,
Yes, only one.
only one.
Respondents.
Okay, appellant submits that Srimati nine, Shobharani Koyal, that is the respondent, defendant, respondent to Go, within bracket GA, Go, has expired, leaving behind her 4 sons and 3 daughters who are required to be substituted. Full stop. Though the substitution, application for substitution has been made beyond time, but the learned counsels representing the respondents number, respondent number 1, and respondent, learned counsel represent the respondents, learned counsels representing the respondents do not raise any objection. Full stop. In such, do not raise any objection as regards to substitution of respondent number 2 Go.
Lordship.
Full stop. The learned counsel paragraph, the learned counsel representing the appellant further submits that the respondent number 4 K, namely Ajit Mondol, আগের জনের নাম বলেছি, namely Ajit Mondol, has also expired, and the application seeking substitution, leaving behind, expired, leaving behind 3 sons and 4 daughters. Full stop. The application seeking substitution of the deceased Ajit Mondol has been made within time.
Lordship.
Has been made within time. Full stop. In such circumstance, let the legal heirs of the paragraph. In such circumstance, let the legal heirs of the deceased respondent number 2 Go be substituted, and the deceased respondent number 4 Ko be also substituted. Full stop. And
Department be directed to amend the cost title.
Learned counsel, you let her go to you, towards you. The department be directed to take note of the proceedings and to record the same. Full stop. এবার হচ্ছে the application being can 13 of 2026 এর আগের লাইনটা লিখবেন application being can 13 of 2026 is disposed of হলো as
And also is fixing any date for a hearing?
Huh?
September, because it will take time and come back. September first week only.
how many days required?
Lordship, sometimes because
11 September, but 4th September is vacant.
Full stop, paragraph. At this stage, the learned counsel representing the appellant submits that a month's time is required to serve notice upon the substituted respondents. Full stop.
কেউ হাজির হবে না
হাজির হবে that is upon them whether they will appear or not or
They will come or not.
but it has to be served হয়ে গেল serve notice upon the substituted respondents full stop হলো in accordingly paragraph accordingly let the matter appear on
Lordship, 11 September or
11
even monthly list of September.
let the matter appear on 11 September আচ্ছা এখানে affidavit of service এই affidavit of service in respect of whom?
Lordship, this application I served upon all because all are not appearing.
Acha.
I served upon all. Lordship.
Acha. Two affidavit of services have been filed. Let those be kept with the record.
Not to new place. I'm grateful, man.
Item number 8. I'm praying for vacating stay. A very urgent matter, my lord, because since January it is being continuing and I am suffering. They obtain stay and complying, making not any payment. On that passing order, your lordship, only opinion that there is limited period.
কি বলে কত অবধি হয়েছে আসলে দেখুন
Lord, I am first pressing a judgment of the Supreme Court.
Learned counsel, the petitioner is not being represented.
So the stay should be vacated. They should be suffered for this.
Yes.
They should be suffered for this.
He was just now. The learned counsel was there when you were moving his. Yes, learned counsel.
Well, Mr. Prathaputim is still engaging court number 7, well, on legs. But, 3. Now passover is difficult.
I am suffering stay, my lord.
Next week, the next
No,
date
no,
is a
no.
long time.
No, no, no.
In the next date before the commission is landed commission on September. Well, kindly keep it on next
Which
week.
date? Which date? September?
Commission.
10th September.
There is a date. There is
10th
state commission. There is a date fixed for payment.
No, Mallet, due to the pendency of this matter, since we are on compromise, Mallet, the landed commission, Mallet, fixed the date on such and on 10th of September, awaiting for the order of this honorable.
So that as the stay is continuing, there is not proceeding.
Yes.
We are suffering.
But kindly keep
10th of September.
Yes, kindly keep it on the
Lord,
next
this is stay since January. Kindly see the lost order cost. On the dating of passing order, your lordship only limited period.
This bench will be available.
Yes, yes, that's true.
Prior
I am
to-
suffering,
prior
Lord. I am suffering. Stay should not be. Matter can be hard. No issue.
Learned advocate representing the petitioners submits that the learned counsel, Mr. Roy, is ছেড়ে দিন ওরমা দেবার দরকার নেই learned advocate representing the petitioners seeks an accommodation for this day on the ground of his senior. Full stop. Accordingly, let the matter appear on the next date when this bench is available. But learned counsel,
My lord.
be prepared and come
Candid, my
if Mr. Roy is not available on the next date.
My lord.
Let
Lord,
matter-
getting the stay, my lord, one line should be added so that otherwise I will be suffering. Any observation, my lord, because I am suffering for
What
this.
observation?
Lord, on the last next day, if they are not possible for taking up the matter, the stay should be vacated because otherwise it will be impossible. In any event, your lord is not sitting. It will continue for
But
last
this is
6
the
months. Finally
First
consider
date
it.
after the order was passed. My lord.
On the next date, if nothing fruitful appears, then you pray. Yeah. এটা কোথা থেকে হলো? হ্যাঁ? ওই কটা আমাকে ছেড়ে গেল কি করে? ওটা তো উঠতে হবে। শুনুন, বিকেলে আসবেন, ঠিক আছে? আর কাকে এনে যে ডাকতে বললাম না, সে তাকে নিয়ে
My lord, in respect of the next matter, my lord, I can understand, my lord, there is a division bench of your lordship, my lord. In respect of the next matter, there is an application which has been taken out seeking substitution. Now, there is an opportunity granted to my learned senior friend.
CO or essay?
It's an essay, my lord.
Item number 11.
Item number 11, yes.
Yes,
Substitution application,
substitution application is necessary.
can 13 of 2026.
My lord, I believe my lord,
11,
No, my
11.
lord, last occasion on
can 5, my lord.
occasion
What to be
university
done? Will be taken up on the next day.
next.
Hmm.